Hi all, welcome to our webinar on the Cyber Resilience Act. My name is Brent Krijns. I am a cybersecurity attorney in the digital cyber and privacy practice of HVG Law. I'm here today with my colleague.
Hi everyone, my name is Gigi. I'm a colleague of Brent, also focusing on cybersecurity law. And we will together talk you through the Cyber Resilience Act today in this webinar. A brief overview of the topics of today. First, we'll guide you through the legal cybersecurity landscape. Afterwards, we'll move through the background and the timelines of the CRA, and then the scope and obligations of the CRA, but also we'll provide you with an overview of the CRA in combination with the AI Act and NIS2. And finally, also very important, we will also talk you through the enforcement of the CRA.
So starting off with the legal cybersecurity landscape in 2024, I think it's important to note that digital law is a very broad topic, and there's a lot of legislation at EU and at a local level that governs the use of technology in business. Specifically related to cybersecurity, there are multiple new acts and directives from the EU, such as the Cybersecurity Act, the NIS2 Directive, DORA, and the Critical Entities Resilience Directive, which have all been enacted to govern cybersecurity within the EU. The Cyber Resilience Act would be in addition to govern a sort of gap in the legislation that has existed up till now, and we're also looking at the Cyber Solidarity Act, which is upcoming. It's important to view the most universal legislation in this area in conjunction with each other, because these laws cover similar topics and similar issues very heavily. Looking, for instance, at the GDPR, DORA, NIS2, and the CRA, we see that they are in some manner focused on sectors. So for instance, the GDPR is focused on everyone who processes personal data, whereas DORA is more sector specific and focused on the financial sector. We see that there's a difference in detailed requirements of the law. So we see, for instance, that the CRA and DORA are very detailed laws, contain extremely detailed obligation related to cybersecurity, whereas the GDPR and, for instance, NIS2 are more principle-based, very high level. What do you have to do to attain a sort of minimum level of cybersecurity? All laws contain some form of reporting obligations to cybersecurity supervisory authorities, or to response authorities, or to market surveillance authorities. All these laws contain some manner of data usage restrictions. For instance, DORA and NIS2 are very low on data usage restrictions, but do have sort of the principles that you should use to govern the use of your data. So, for instance, how do I safeguard the availability and integrity of my data? GDPR is, of course, very heavy into the use of personal data, and the CRA is even further with data minimization principles. So, for instance, CRA has a very large onus on covered entities to use data in an appropriate manner. Lastly, for third-party risk management, all different laws cover some form of third-party risk management and supply chain security, meaning that in some way you always have to think about your suppliers, also your customers, and also their customers to some extent, because the entire supply chain has to be secure. Moving on to the cyber threats, because there's a reason that these different laws are enacted and that these different laws govern this specific topic. ENISA, the European Cybersecurity Authority, has identified in their threat landscape different specific cybersecurity threats that they believe are the most accurate and the most actual in current times. An important one that is governed by all these laws, for instance, third-party risk management, is governed because of supply chain attacks. So supply chain attacks are a very big risk, apparently, in the EU, meaning that it is important to legislate this further.
So what was the exact reason that the CRA was needed? As Brent just told, there was a certain gap within the current landscape of cybersecurity regulations. One example within the Netherlands was a cyber attack on help devices for the elderly. Those buttons worn by elderly, and if they click the button, there would be a notification to an alarm center so the sufficient aid would come to their location. Well, due to a cyber attack, those buttons weren't working. There wasn't any notification going out, meaning that thousands of elderly or other people who required such aid weren't able to get the assistance they needed. Similar situations arise within the hacks of baby monitors, having external hackers providing themselves with access to the monitors on several occasions. And all these cyber attacks on software, but also hardware, accounted for more than 5.5 trillion euros, at least in the year of 2021, a number which is still rising up till date. And from the European legislator, there were two major reasons and problems with the current situation of hardware and software. So first of all, it was established there was a too low level of cybersecurity within those products, and that resulted in a high level of vulnerabilities and insufficient security updates in those products. Secondly, on the user side of those products, there was insufficient insight into, but also access to information by the users, leading to the users being unable to choose products which had sufficient cybersecurity or even to use them safely. Well, as we know, there's a growing independence in cross-border connection of devices, creating also a higher need for a higher cybersecurity level for those products and standards. And that is where the CRA comes in. So CRA is a very important but also special type of legislation because it combines both product safety and cybersecurity, and that fills the gap within the current European legislation regarding products with digital elements. It's also important to note that a lot of people make the comparison to the Radio Equipment Directive, which is a European legislation on certain products with digital elements, but the CRA has a broader scope. So it's also in relation to both hardware and software, but also more than just wirelessly communicating devices. And it also has very explicit requirements and procedures for the reporting and addressing for several cyber vulnerabilities. And that's also very new. Again, filling gaps that are currently or previously were still in place. With regard to the timelines, so the Cyber Resilience Act is really the newest bit of legislation. It was adopted on 10 October of this year. But the proposal of the CRA was published by the European Commission in September of 2022. And in accordance with European procedures, there were heavy trialogue sessions happening in Q3 of 2023. And then finally, the compromise text was published on 20th December of 2023. So we're currently awaiting the publication of the CRA in the EU journal, and then a phased transition period will commence. Eventually, 36 months from that period, the organizations need to comply with the CRA. So first, a brief overview. What is the Cyber Resilience Act? Most important thing is to know that who it covers and what it covers. So first of all, the who. There are three important economic operators in the supply chain who will have obligations under the Cyber Resilience Act. So first of all is the most important category. Those are manufacturers of the products. But secondly, also distributors and the importers of those products. And what's the scope? What's the what under the CRA? It's products with digital elements, meaning both software and hardware, but also including components for software and hardware, meaning it's a very broad scope, and we emphasize that scope later on in this webinar. And the most important goal is that it will have cybersecurity requirements for the entire lifecycle of those products, creating elaborate responsibilities for the entire chain of economic operators.
So first, taking a look at the goals of the Cyber Resilience Act, as Gigi just mentioned, the biggest part of the Cyber Resilience Act is to ensure that throughout the life cycle of products with a cybersecurity element, that there is an ensurement of those cybersecurity standards. To do this, there is a set of essential requirements for the design, development, and production of products with digital elements and obligations related thereto. Then there is a set of vulnerability handling requirements. So that's more so aimed at the market operators themselves. So they have certain vulnerability handling requirements that they have to comply with, which are more organizational requirements. And then finally, there is a standard of market surveillance and enforcement to ensure that all these elements are complied with. So by regulating these four aspects, they hope to increase the level of cybersecurity of products with digital elements. What are then the products with digital elements? That's actually quite interesting because it's a very broad scope. A product with digital elements itself is any software or hardware product and remote data processing solutions, including software or hardware components marketed separately. I think the most important part to think about this is it could be anything as long as there is a connection to an external device or network. So it could be a smart fridge, for instance, it could be a camera, it could be a printer, it could be a phone, basically any hardware or software product. So also apps, for instance, that have an external connection, which can be direct or indirect, logical or physical, to a device or network. Specifically excluded are those devices which are elsewhere regulated, which are related to aviation, related to marine equipment, related to motor vehicle safety, related to medical devices, related to national security, defense, and intelligence, and software as a service, which is specifically regulated by the NIS2 directive, to the extent that there's not an overlap. Regarding this overlap, we'll get into that later. The CRA distinguishes 4 different categories of products with associated cybersecurity risks. So the European legislator has made this classification of these different types of products based on several criteria, such as their functionality, the intended use in sensitive environments, the intended use of critical or sensitive functions, the potential magnitude of adverse effects, or whether the use of such products has already caused tangible or intangible losses or distortions, or has given rise to significant concerns. So what are the 4 categories then? Those are the non-critical, so basically every product. The important products being listed in class 1, which is a slightly lower class, so not as risky, but still important. Then a riskier class being class 2, which includes, for instance, firewalls, intrusion detection and prevention systems, and finally critical products, which is a very, very short list, but this includes, for instance, smart cards. Basically, what the European legislator has said is that the critical products have a significant effect on the entire sort of supply chain and the IT value chain, and there are critical dependencies related to these products. So it's very important that these products specifically have a very high standard of cybersecurity.
Yes, so now we've elaborated on what are the products governed by the CRA. It's important to dive into the who. So the economic operators under the CRA, the most important category being the manufacturers of products with digital elements. And in accordance with the CRA, the definitions of a manufacturer is any natural or legal person who develops or manufactures products with digital elements or has products with digital elements designed, developed, or manufactured, and markets them under his or her name or trademark, whether for payment or free of charge. So it's very important to know that a manufacturer is not just an organization who does a direct manufacturing itself. It can also be that it asks another third party within its supply chain to develop or manufacture the product for them, after which it will put it on a market under his or own name. And it can either be for free or for a payment. So there are various options possible to be a manufacturer in regard to the CRA. Well, diving into the specific obligations, the CRA has obligations for manufacturers and other economic operators for the entire life cycle of a product. So first starting with the cybersecurity risk assessment and due diligence. So once a manufacturer is intending to develop a product, it needs to assess what are the cybersecurity risks involved with the development, but also putting it on the market of this product. And also it's important to do due diligence, because when it comes to products with digital elements, there are often a lot of third-party components involved. So it's very important that a manufacturer also does a very sufficient due diligence process on any third-party and components, ensuring the entire risk assessment covers the entire product, including any third parties involved. So once that process is finalized, it needs to ensure that the right cybersecurity measures will be implemented. So the CRA has a very elaborate list of obligatory cybersecurity measures. Some are very defined and very specific, but some are more broader terms, which are again colored in by the risk assessment done in the first phase. So for example, it's very important to do a security by default configuration, providing automatic and free of charge security updates to the products, making sure the right access controls are maintained, providing and using data minimization principles, and eventually also limiting any attack surfaces in the product itself.
Once the manufacturer has implemented all these measures, there's time for a conformity assessment. And a conformity assessment is basically a check whether the product as designed and developed actually complies with the cybersecurity requirements in the CRA, and whether the manufacturer itself complies with all the vulnerability handling requirements in the CRA. Provided that a conformity assessment is successful, the manufacturer is then required to establish a declaration of conformity and affix a CE marking to their product. It's important to note that there are different types of conformity assessment procedures within the CRA. Mainly there is a self-assessment, which is available to every product. So basically all the low-risk products can do a self-assessment. But once you get to the higher risk products, you may need to do a third-party conformity assessment, or you need to adhere to cybersecurity standards. Once the product is placed on the market, you'll have initiated the vulnerability handling processes. So during the entire predetermined support period, so the life cycle of the product, you need to identify and document vulnerabilities, you need to address vulnerabilities and remediate those without delay, and you need to be on top of things with testing and review to ensure that you're always aware of any vulnerability in your product. Once you have fixed a vulnerability, you need to publicly disclose this to all your customers so that they are aware that they can, for instance, download and update and fix their product. Finally, you also need to implement a policy on coordinated vulnerability disclosure to ensure that vulnerabilities that are universal within certain product types, for instance, are handled by all manufacturers in a similar way. Once you have an incident, so for instance, an exploited vulnerability or an incident where data has been leaked, you have an incident management process. So starting off, within 24 hours, you need to send an early warning indicating at least the member states, the geography where the incident has occurred. Then you need to submit an updated incident or vulnerability notification, providing further information such as what is the suspected cause of the vulnerability, has it been exploited, if so, on what scale. Within 14 days for vulnerability notifications or 1 month for incident notifications, you need to issue a final report to the supervisory authority on the mitigating measures that you've taken. And as soon as possible, you need to submit a notification to all impacted users that there is a vulnerability and what they can do to, for instance, patch or update or adjust their settings accordingly. Another obligation under the CRA is the process of maintaining technical documentation. So, for instance, in your technical documentation, so let's say the instruction manual that you send along with a hardware product, you need to include cybersecurity specific information. So you need a product description, for instance, that also shows the intended purpose of software included in the product. You need to perform the cybersecurity risk assessment as a start when you design and develop a product, and you need to include the findings of your cybersecurity risk assessment in that technical documentation to show users, but also supervisory authorities, that your product is compliant and that all cybersecurity risks have been taken into account. When you have a declaration of conformity and a conformity assessment procedure performed, you need to include that in your technical documentation to show that your product is compliant with the Cyber Resilience Act. Finally, for certain products where it is required, you also need a software bill of materials, so showing all software used in your product. You need to do this before placing it on the market, continuously update it during the support period, and where possible, for instance for AI, you can combine it with required technical documentation for other regulations such as the AI Act.
Yeah, because supply chain risk management is so important within cybersecurity, the CRA not only focuses on obligations of manufacturers of digital products, but also has specific obligations for both distributors and importers of those products. One important remark to make is that even when you're just distributing or importing a product, it could be that you're also classified as a manufacturer of a product, especially when you market the product in your own name, labeling it with your own trademark. So for the user, you are seen as the manufacturer of that product. which could technically mean that you also need to comply to the manufacturing obligations of the CRA, even when you think you perhaps are just a distributor or importer of this under the CRA. So what are the general definitions of distributors and importers? Well, first of all, a distributor is any, again, natural or legal person in the supply chain, other than the manufacturer or the importer, that makes a product with digital elements available on the union market without affecting its properties. So it basically is purchasing it and reselling it within the EU market without adjusting any of its settings and really making a change to the product itself. An importer can also, again, be a natural or legal person which is established within the EU, but places on the market a product with digital elements that bears the name or trademark of a natural legal person established outside of the Union. So the importer has a very important place within the supply chain because it's the interlink between the outside of the EU and putting products on the market within the EU. And that also has an impact on the obligations that it has under the CRA. So their key obligations is first and foremost due diligence, really ensuring that all the parties before them in the supply chain, so the manufacturer or perhaps the importer, complies with their obligations under the CRA. So for example, it needs to check the conformity assessment being done by the manufacturer. Is the right CE marking affixed also on the products? Is the required technical documentation added to the product? Are there sufficient instructions for the user available of that product? How is it handled with regarding to vulnerability disclosure? So for example, if the importer or distributor suspects there is a vulnerability actively being exploited, it needs to make sure it has the right vulnerability disclosure processes in place, and that it also reports those vulnerabilities to both users and the market authorities. They have a very important role within the product management of cybersecurity products. So if they suspect that a product is not compliant with the CRA, if it has certain risks to cybersecurity, it can recall and withdraw the products and get them off the market to ensure that any further damage is being done within that supply chain.
So looking a little further on what we already discussed a little, the AI Act and NIS2, there is some overlap between those sets of legislation and the CRA. And crucially, the AI Act, which is focused on AI products in general, has some overlap in mentioning explicitly that AI systems have to be resilient and have to be cybersecure by design. There is an overlap in that because in Article 12 of the CRA, it is stated that the required AI Act conformity assessment, specifically the parts that relate to cybersecurity, can also be left out for the AI Act if done for the CRA. So provided that you show that your AI system is compliant with the CRA, which you may be required to do pursuant to the CRA, you do not have to do the same conformity assessment again for the AI Act. The overlap between NIS2 and the CRA, on the other hand, is a little different in design. So NIS2 is focused on the important and essential sectors within society, and it is designed to raise the minimum standard of cybersecurity through cybersecurity risk management for those sectors. Now, those sectors include cloud computing services. So that is, for instance, a software as a service provider, but it could also be a platform as a service. To the extent that you provide flexible and scalable computing services through cloud methods, you do not necessarily have to comply with the CRA. However, when you issue products that use cloud computing services to function, that's when NIS2 and the CRA overlap. And you may need to comply with both things. So there's not really an essential overlap within the CRA or within NIS2, so it's not necessarily by design that there are certain things you have to comply with on one hand and certain things you have to comply with, for instance, CRA. That's not the case. So you really have to look into then, what do I need to do to comply with NIS2? What do I need to do separately to comply with CRA? And in that sense, it's important to note that the NIS2 is mainly focused on organizational requirements. So how do I, as an organization, handle my cybersecurity risks? Whereas the CRA is mainly focused on product requirements. So how is this product made cybersecure and safe? In that sense, there is some slight difference in the way you need to approach an overlap in these laws.
Yeah, so finally, of course, there are a lot of obligations being newly introduced under the CRA, and each country within the EU will appoint a dedicated authority to perform the enforcement of the CRA. For the Netherlands, it's not yet known which authority this is going to be, and it could be a newly set up authority or a current authority. And of course, there are also some sanctions that will apply if there's non-compliance established. So we have three different categories. First of all, if there's a failure established to comply with essential cybersecurity requirements laid down for the manufacturers, it could lead up to a fine of up to 50 million euros or either 2.5% of the total worldwide annual turnover. If it's established that any other obligation of the CRA is being failed to comply with, a fine could be levied up to 10 million euros or 2% of the total worldwide annual turnover. But also, even if it's not considering the obligations being in non-compliance there too, if, for example, manufacturers requested to provide information to the authorities and then it's established that that information is either incorrect or incomplete or perhaps misleading, that could also be the cause for a penalty leading up to 5 million euros or 1%. So those were the most important topics on the CRA. Thank you very much for listening.
Thank you all for joining and have a very nice day.